Bangladesh Company has its roots in the Joint Stocks Company under 1844 enacted the Parliament of the United Kingdom. It was later influenced by the Company Act 1, Companies Act 1913 and Companies Act 1929. The Securities and Exchange Ordinance 1969 was the most important piece of legislation incorporating corporate activity during the Pakistan period. After the independence of Bangladesh, most petition activities during the served as a model for reform. The Company Law Reform Committee was set up in 1979 with leading civil servants, chartered accountants and lawyers. Committee's recommendation was not implemented until 1994 when the Company Act of Bangladesh 1994 was passed by the Jatiya Sangsad. The Securities and Exchange Commission Act of 1993 created the Bangladesh Security and Exchange Commission to observe the country's stock market. Company definition under the Act 1 of 2. In this Act, unless there is anything repugnant in the subject of contents, it is stated that a. Articles. Articles means the article of association of a company include so far as they apply to the company the legislation contained in Schedule 1 to this Act, provided that the article of association of a company formed under any law relating of companies at the time in force before the commencement of this Act shall, so far as they are not inconsistent with the provisions of this Act, the deemed to be the article of association of the company formed in accordance with the provision of this Act. B says banking company. Banking means a bank company as defined in Section 9 of 5 of the Act 1991, Act No. 14 of 1991. C. Company means a company formed and registered under this Act of the existing company. D. The court. The court means the court having jurisdiction under this Act. E. Debenture, including debenture, stock, bond, any other securities of a company, whether constituting a charge on the asset of company or not. F. Director, include any person occupying the position of director by whether name called. J. Distinct court, means the principal civil court of original jurisdiction in a district but does not include the High Court division in the exercise of its ordinary civil procedure. H. Existing company means a company formed and registered under any law relating to companies in force at any time before the commencement of this Act and its operation after commencement of this Act. H. Existing company means a company formed and registered under any law relating companies in force of any time before the commencement of this Act and its operation commencement of this Act. there will be a disturbing something, so I have to turn it out. And what about this? Okay, left it. Very bad situation, harassing, sorry. Okay, I was in the section A, and I'm going to jump I. The financial year. What does mean the financial year for a company? The financial year means in relating to any body corporate, the period in respect of which profit and loss count of the body corporate rate before its annual general meeting is made within the period in a year or not, provided that in relating to an insurance company, financial year shall means the calendar year. J. Insurance company means a company that carries on a business of insurance either solely or in common with any other business or businessman. K. Manager means an individual who, subject to the superintendent's control and direction of the board of directors, as a management of the whole of substantially the whole of the affairs and business of a company, and include a director or any other person occupying the position of manager by whether name called and whether under a contract of service or not. Here is a point I want to discuss, that in a human resource management for master's level, people doing higher study, home and abroad, when they design a compensation or office settlement management or talk about the either engineering, they always call manager. They never told about the CEO, the admin. They only use the keywords, but manager always use. They think manager is the powerful man for a company. Whatever. L. Managing agent means a person, firm or company by whether name called who or which is entitled to the management of the whole affair and business of a company by virtue of an agreement with the company, and under the control and direction of the direction except to the extent, if any, otherwise provided for in the agreement. M. Managing director means the director who by virtue of an agreement with the company or of a resolution passed by a company in its general meeting or by the directions of a virtue of its memorandum or article of association, entrusted with the substantial power of management which would not otherwise be exercisable by him or her, and include a director occupying the position of managing director by whether name called, provided that the power to do administrative acts of a routine nature when authorized by the directors, such as the power of affix common seal of the company to any documents or to draw or endorse any check of the account of the company in any bank, or to draw and endorse negotiable instruments, or to sign any certificates of share, or to direct registration or transfer for any shares shall not be deemed to be included within the substantial power of management. Provided further, what a managing director of a company shall exercise his power subject to the superintendent, the control and direction of the directors. In memorandum, a memorandum of association of a company as originally framed of and entered in pursuance of the provision of this Act. Officer means a director, managing agent, managing secretary, or any other officer of a company, and also includes when the managing agent is a firm, may partner in the firm, individually manager and also the partner. Good position. 2. When the managing agent is a body corporate, any director or manager of the body corporate. 3. When the secretary is a body corporate, provided that except of the purpose of the section 331, 332 and 333, the firm officer shall not include an auditor. P. Subscribed means that irrespective of the provision and this Act relating to the winding up of companies prescribed by rule made by the Supreme Court and as a respect of other provision of the Act prescribed by the government. Q. Private company means a company which by its Article 1 restricts the right to transfer its shares if any. 2. Prohibits any invitation to the public and subscribe of its share or debenture if any. 3. Limit the company of a member to 50, not include persons who are in its employment. Provided that there are 2 or more persons hold 1 or more share in a company jointly, there shall be the purpose of this definition be treated as a single member. R. Public company means public company is the company incorporated under this Act or under any law at any time in force before the commencement of Act and which is not a private company. S. Registrar means a register of any other officer by whether designation performing under the Act of duty of registration of a company. F. Schedule means a schedule to this Act. U. Secretary means any individual possessing the prescribed qualification appointed to perform the duty which may be performed by a secretary under this Act and any other ministerial or administrative duties. And B. Share means a share in the capital of the company and include stock except when a distinction between stock and share in essence implies. 2. For the purpose of this Act, a company shall subject to the provision subsection 4 deemed to be a subsidiary of any other if A. That other contrast of the composition of board of directors of the first mentioned company. B. The first mentioned company being an existing company has before the commencement of this Act issued preference share and holder of which have the same voting right in all respects as the holders of equity shares and that other company exercise to control more than half of the local voting power of the first mentioned company. Or C. The first mentioned company is not subsidiary within the meaning of clause B, but the other company holds more than half in nominal value of its equal shares capital. Or D. The first mentioned company is a subsidiary of the third company, which is that other's subsidiary. Three other purposes of subsection 2. The positioning of the company board of directors shall be deemed to be controlled by another company if the other company, by the exercise of some power exercisable by it at all directions within the consent of currents of any other person, can appoint or remove the holder of all or a majority of the directors, and for the purpose of this subsection, that other company shall be deemed to have power to appointment to the directorship with respect to which any of the following conditions is satisfied, that is to say, a. The power of appointment cannot be exercised except in favor of an individual. B. That an individual appointment thereto follows necessarily from appointment as director, managing director, secretary, or managers of or to any other officer of employment in that other company. Or C. That the directorship is held by an individual nominated by that other company or a subsidiary thereof. 4. The determining whether one company is a subsidiary on another, the following conditions shall be applicable, namely, a. Any share held or power exercisable by that other company in a fiduciary capacity shall be treated as not held or exercisable by it. Be subject to the provision of clause C and D, by share held or power exercisable shall be deemed to be the sharehold or power exercisable by the other company if J. The share are held or the power is exercisable by a person as a nominee and on behalf of the other company, but this clause shall not apply to the holding of such shares or to the exercise of such powers by such person where that other company is concerned in a fiduciary capacity. Very important point. 2. The share are held or the power in exercise by the subsidiary or that other company or by a nominee or such subsidiary, but this clause shall not apply to the holding of such shares or to the exercise or such power by the subsidiary or by the nominee when the subsidiary is concerned in a fiduciary capacity. C. Any sharehold or power exercised by any person by virtue of the provision of any debenture of the first mentioned company or of a trust deed for screening the issue of such debenture shall disaggregate. D. If any share or held of power is exercisable or held at the Now I'm going to jump for the memorandum of association. This is a very important practice for a company establishment. The memorandum of association and the company is thereby specified prohibited to pay any dividend to its member of accordance with the requirement of the Section 28 of the Company Act 1994. The time of dissolution under intimation of the government. Prospectus. A prospectus means any documents described or issued as a prospectus and include any notice, circular, advertisement, or other documents initiating deposit to the public or documents inviting officers from the public of the subscription of share of debenture in company. As prospectus also include self-prospectus and a hearing prospectus. Prospectus is not merely an advertisement. Document called the prospectus is satisfy two things. The paper should be a prospectus if 2 points includes 1. It invites subscriptions to share or debenture or invite deposits. 2. The aforesaid invitation is made to the public. Content of a prospectus. What points should be enriched on a prospectus? Address of the registered officer of the company. 2. Name and address of company secretary, additional bankers and underwriters, etc. 3. Dates of the opening and closing of the issue. 4. Declaration about the issue of allotment letter and refund within the prescribed time. 5. A statement by the board of directors about the separate bank account where our nominee receipt out of shares issued are to be transferred. 6. Details about underwriting of the issue. 7. Consent of directors, auditors, bankers, and other issue expert opinion, if any. 8. The authority of the issue and the details of the resolution first therefore. 9. Procedure and time schedule for allotment and issue of securities. 10. Capital structure of the company. 11. Main objectives and present business of the company and its location. 12. Main objects of public offer and term of the present issue. 13. Minimum subscription amount payable by way of premium, issue of share otherwise than on cash. 14. Details of directors include appointment and remuneration. 15. Disclose about sources of promoters and contributors. 16. Particular relation through management perception of risk factor specified to the project. Registration period of the project, extent of progress made in the project and details of the completion of the project. Various category of prospectus. 1. Statement in lieu of prospectus. A public company which does not raise a capital by public issue need not issue a prospectus. In such a case of statement of lieu of prospectus must be filed with the registered 3 days. Therefore, the allotment of share of debenture is made, it should be dated and signed by each director or proposed director and should contain the same particular as they require in case of prospectus project. 2. Deemed prospectus. In the article of Section 25 of the Company Act 2030 provides for documents containing offer of share on debenture for sale shall be included within the definition of the term prospectus and shall be deemed as prospectus is implication of law. Unless the company is provided the allotment of one agreement to allot a share on debenture shall be deemed to have been made with a view of the shares of debenture being offered for sale of the public in a shown. That the offer of the share of debenture of any company or individually deemed for sale of the public was made within 6 months after the allotment of agreement is allowed, or B. that at the date when the offer was made, the whole consideration to be received by the company in respect of the share of debenture has not been received by it. On enactment of the rules of law of the content of the prospectus shall apply. Deemed prospectus. 3. Abridged prospectus. Abridged prospectus means the memorandum containing such salient feature of the prospectus as may be specified by the ACBI by making regulation in this behalf. No form of application of the purchase of any other securities of a company shall be issued unless such forms are accompanied by the abridged prospectus. A copy of the prospectus shall, on a request being made by any person before the closing of the subscription list and the offer influence on him. Requirement regarding issue of prospectus. The Code of Company Act has defined some legal requirements about the issue and registration of the prospectus. The issue of the prospectus would be deemed to be legal only if the requirements are met. 1. Issue after the incorporation. As a rule, a prospectus of a company can only be issued after its incorporation. A prospectus issued by or on behalf of a company or is relating to an intended company shall be dated, and the date shall be taken as the date of publication of the prospectus. 2. Registration prospectus. It is mandatory to get the prospectus registered with the Register of Companies before it is issued to the public. The procedure of getting the prospectus registered is as under: A. A copy of the prospectus duly signed by every person who is named therefore as a director of the proposed director of the proposed prospectus of the company must be filled with the registered company, therefore the prospectus issued to the public. B. The following documents must be attached thereto. 1. Consent to the issue of the prospectus required under any person as an expert confirming his written consent to the issue thereof, and that he has not written a consent of the affordable appears in the prospectus. 2. Companies of all contracts in the Act into which respect to the appointment of the managing director Directors and other officers of the company must also be filled with register. 3. If the auditor or accountant of the company has made any adjustment in the company's account and said adjustment and the reason therefore must be filled with the documents. 4. There must be a copy of the application to be filled for the issue of company's share and dividend attached with the prospectus. 5. The prospectus must have written consent of all persons who have been named as auditor, solicitors, bankers, and brokers, etc. 3. Section says every prospectus must have on the force of a statement that 1. A copy of a prospectus has been delivered to the register for registration. 2. Specifies that any document required to be endorsed by a section have been delivered to the register. A copy of a prospectus must be filled with registers of companies. According to the section 26, a prospectus shall be issued more than 90 days after the date on which a copy thereto delivered for registers. If a prospectus issue a contravention of the above stated provision, then the company and every person who knows a party to the issue of the prospectus shall be punishable with a fine. Must be by the court or internal auditors. Misleading prospectus or misstatement in prospectus. A prospectus is said to be misleading or untrue if two following cases found. Here 1. A statement included in the prospectus shall be deemed to be untrue if the statement is misleading in the form and content in which it is included, to omission from prospectus of any matters of misleading in inventors. Criminal liability for misstatement in prospectus. Under the section 34 says, if you do any criminal steps, then what should be the punishment? There a prospectus issue circulated or distributed. 1. Include any statement which is untrue or misleading in form or content in which it is included untrue. There may any inclusion or omission of any matter is likely to mislead. What you are not doing, but you are saying you are perfect or efficiency in the text. This is a criminal step. Every person who authorizes the issue of which prospectus shall be liable under section 447, it is fraud. He is defined as the fraud. Defenses available in this section are: 1. Person proof that the statement or omission was immaterial. 2. Person has a reasonable ground to believe and did believe that the statement was true. Or 3. Person has a reasonable ground to believe and did believe that the inclusion of omission was necessary. Civil liabilities for misstatement in prospectus. Statement under the section 35. Where a person has subscribed for securities of the company, acting upon any misleading statement include the omission and has sustained any loss or damage of his consequences the company and every person who 1. It is director through the time of the issue of prospectus. 2. Is named as director or a proposed director with his consent. 3. It is promoter of the company. 4. As authorized the issue of the prospectus. And 5. It is export. Shall be liable to pay compensation to effect a person. The civil liabilities shall be in addition of the criminal liabilities under section 36. There is a proof that the prospectus has been issued with intent to defraud the application for the securities to company or any other person, or for any fraudulent purpose. Every person shall be personally responsible without any initiation or liability for all the any of the losses or damages that may have been incurred by person who subscribed to the securities and basis of which prospectus. Defenses under the section are: 1. He has withdrawn his consent or never give this consent. 2. The prospectus has issued without his knowledge or consent, and when become aware, gave a reasonable public notice that prospectus was issued without his knowledge of consent. Now a very important thing, that is meeting. A company is considered as a legal entity separate from the member of the eyes of law. All the affairs of the company are partially carried out by the board of directors. The board of directors of a company carried out this affair with the limitation of their powers as involved by the article of the association of the company. The directors also exercise certain power of their own with the consent of other members of the company. Here is some points. I am not going to read through. The types of meeting: stationary meeting, process of stationary meeting, this on demand, adjustment of stationary meeting, default, stationary report, how to make, and the process and the act, annual general meeting. This is very important. Annual general meeting, very important. The annual general meeting is subjected to 3 rules. 1. Meeting must be held every year. 2. A maximum gap of 15 months is allowed between the annual general meeting if mandatory. Three, the meeting must be held within 6 months from the preparation of the balance sheet. Failure of comply with the above rule will be considered as an offense to the Companies Act by the law and will be treated as a default unless the legal registers grant extension of time for holding a meeting, date, time and place. This is based on the annual meeting, the holding annual general meeting, extraordinary general meeting. Extraordinary general meeting can be covered by the board of An extraordinary general meeting can be converted by the board of directors or on the requisition of members by the requisition themselves on the failure of the board to call the meeting by the company law board. By the board of directors, I'm skipping. This is important, I cannot skip. Meeting of BOD. The meeting held by the Board of Directors is an important aspect for the smooth functioning and working the company. For ensuring that the action provided by the board there is the interest of the Company Act 1956 incorporated several stationery prospectus. Periodically of the board meeting. According to Section 285 of the Companies Act, the board meeting should be held every 3 months. The board of directors can meet any day between the 1st January and the 31st of March. According to the next meeting company be held between 1st April and 13th June. There is no scope in the Section 285 of the Companies Act for backward calculation. Notice board meeting. According to the Section 286 of the Companies Act, appropriate notice should be given to all the directors about the meeting. The meeting can be held only after the board is given. The notice should be delivered to every director of the board. The notice board delivered in the last 7 days before the meeting. It is not mandatory to give notice to a foreign director staying outside the country, Bangladesh or India. However, it is advised to deliver notice to all the directors whether inside India or outside or of the Bangladesh. Day of holding meeting. Generally, board meetings are held during the day within business hours. However, board meeting can also be held on a public holiday. Time of holding board meeting. The Company Act 1956 does not impose any restriction on the timing of the board meeting. They can be held during or outside business hours as per the convenience of the board. Place of holding board meeting. Board meeting can be held anywhere as per convenience of the board. Quorum of the board meeting is also important. Kinds of a company meeting. Then the summary says the meeting of a company may be classified into following categories. Meeting of shareholders, that means stationary meeting, annual general meeting, AGM, extraordinary general meeting, class meeting. 2. Meeting of directors. Meeting of the board of directors, BOD, meeting of directors, meetings of creditors, meetings of debenture holders. Dear listeners, this was a short note I collected from the renowned PowerPoint presentation and some jurisdiction dictionaries and also internet, the important topics. I think the students home and abroad will be benefited with this lecture who are very lazy, don't want to read at home. It is a very good opportunity to read with me. I am just reading with you all. Thank you. Peace upon all you. Always stay with me. Email me, ask me questions with me on any occasion. Thank you so much. Allah Hafiz.